March 5th, 2020 meeting of the regular meeting of the Pinehurst Planning and Zoning Board to order. We do have a quorum, and if we need to do business, we can, but apparently, the agenda has been modified, but before we get to that, I'd like to get the approval of the minutes of the February 6th, 2020 meeting taken care of. The material was included in your packet. Has anybody any problems, questions, concerns? If not, I'll entertain a motion to approve those minutes. Second? Motion by Sonia, seconded by Cindy. All in favor?
Aye.
Aye. Opposed? Unanimous.
I'll abstain because I wasn't there, so I'm
Thank you. The February 6, 2020 minutes of the Planning and Zoning Board of the Village of Pinehurst have been approved. Now, with respect to our program this afternoon, there was previously issued that there would be a discussion as a work session on a potential development in the Pinehurst South area in the Blake Boulevard locations that a potential applicant has proposed, and we were going to have a work session on that, but that application or that request has been pulled by the applicant, and we have no further information as to when or where or why our next discussion is going to happen. And
Is that something that we had seen before?
Yes, David,
It's the same area, the same properties, the same folks involved. And I know you missed out on some of our latter meetings, but a small group of the Planning and Zoning Board had met. I want to say we had 3, maybe 4 meetings, with the folks to kind of try to. Is there some revisions? Is there something we can kind of come to some consensus? And I think they were very fruitful. I think both sides listened very well, and so there had been a very different sketch plan from what was actually sent to you guys the first round. So this was an attempt to kind of continue that, but now bring it to the full board as a work group. Now we know that we've got an adopted comprehensive plan, what the comprehensive plan says, and with this specific request, the folks did want me to, apologize for the late dismissal and ask of the change of the agenda item, but they're still working on an updated plan, and they didn't think they could get something to us and didn't want to waste anyone's time for today.
Thank you.
Mm-hmm.
the next item on the agenda is an update on future planning and zoning board items. And Mr. Cameron, you're the lead on this one.
So obviously we kind of touched on one just previously. So staff will be in touch if any other work session is a request to have a work session, discuss any other future proposals, map or text amendments to you guys. One that staff has been working on pretty diligently now for several months. As you guys know, there's not been a whole lot of business before this board, so it's freed us up to really work on a tree preservation ordinance. And we are at the really cleaning stage of the part now, where staff is even working on some diagrams to kind of help with the text. So we hope to maybe have an update on that even next month maybe, so we can have some sort of timeline if we can move forward with that. Also an update to the board, at the last council meeting, Village Council gave staff to go ahead and pursue and send an RFQ for 2 of the focus areas for small area plans. One being the focus area 2, the Pinehurst South area, and the other being the New Core Rattlesnake Trail area. So we will be able to start making some progress on that.
What was the driver for the tree preservation plan? flashing green and red, so I don't get it. Yeah, I've tried it a few times. Now it's on? Okay, voila. What's the driver for the tree preservation plan? Was that something requested by Village Council?
Well, it was a little bit of everyone had kind of initiated that. David, you may recall, since you're one of our more seasoned members here, I would say back at least a couple of years ago, there's been a lot of concern in the area. Folks have used this platform and village council meetings as a platform that there's a growing concern with new residential lots being completely clear-cut by the developers, and then the tree requirements that are required for you to get your final zoning approval felt have been lacking. So we initiated this. Leo helped me. It may have been 3 years ago. There was a meeting with, this is when Bruce was still on staff with us, and the village manager, Leo, and kind of sort of outlined which direction we wanted to go. And then, as we know, we all got really busy there for a little while. So there's just been some concern by the citizens here about if we can and how can we best attack clear cutting. And I will say, and Leo can reiterate for this, it's been very difficult to draft some type of language for this. But I think we like where we are now.
Do we have any precedent, like some other community that's done it, or North Carolina statute, or anything that we can draw on to get there?
I think if we did, I think we would have had a lot more progress than we have now. It's a little, there's some of the granting of power statutorily is a little vague. So we've reached out to our folks with school of government. We've consulted with other folks and kind of gotten a good direction. Some can still argue either or. Some municipalities and other jurisdictions in the state actually have special legislation that has been granted to them, mostly in the mountain and some along the coast, as you could imagine. So that's another avenue that the village may want to pursue, is see if there's a way for us to gain some traction to get some special legislation. So it's that much clearer what we can and can't do.
Thank you.
Any other comments, discussion on those items? If not, Alex has arranged a couple of items for training sessions with material furnished by the UNC School of Government concerning amendments to the ordinance and conflicts of interest. Each one is about 35 minutes long. And again, Alex, will shovel it over to you.
All right, thanks. And again, as mentioned before, you know, we've had some light agendas before the Planning and Zoning Board. So staff's always looking at opportunities. I kind of picked on David earlier by saying he was one of the more seasoned guys here. We've got some newer faces. So any opportunity we can get to give you guys a little bit of training. It's a refresher for staff. You know, sometimes, you know, when we have things come in wave after wave, you know, we can kind of lose sight of, you know, really some of our basics that we kind of need to keep our tools sharp. And I know a lot of you guys have seen some of these in the past, so I tried to pick a couple of topics that I know we haven't really looked at most recently, but ones that are still very pertinent to items that are coming before this board. And intermittently through these modules, since they are a couple of years old, there's going to be some new legislation goes into effect the first of the year of 2021. It's a consolidating of the county and the municipal zoning power statutes. It's called 160D. And for the most part, it's just clarified some language, put everything all in one place. And with that, however, there are a couple of updates and a couple of changes. So whenever it's prudent, I'll kind of step in and give you guys a little update on that too as we go through this. Leo, Darren, and I, and Darren apologizes for not being here. I don't think that's real sincere because he's somewhere in the Caribbean right now.
Hopefully not on a cruise ship.
He is actually on a cruise ship. So he'll be back with you guys next month. But we picked these two topics. Again, the first one is going to be amending the local ordinance and local map, which is statutorily what you guys are reviewing. If anyone proposes such, you're heavily involved. So with that, we'll turn it over to our colleague, Mr. Dave Owens, with the UNC School of Government.
Illustrate the points we'll cover in this module. Here's the case we'll use. Meet Melanie, a local real estate developer. She has recently acquired a 10-acre tract in Normalton. The lot is vacant. Most of the land around the tract is occupied by single-family homes. However, one side of the property is bounded by Main Street, a major city street. Melanie's parcel is a mile or so out from downtown, but the street has a fair amount of commercial development between this lot and downtown. Melanie thinks her property is ideally suited for commercial development. She would like to build a large grocery store, along with space for several smaller businesses, such as restaurants, banks, and perhaps a service station. The site, like most of the surrounding land, has long been zoned R15, a single-family residential district. In order to build her project, the site would need to be rezoned to B3, Normalton's general commercial zoning district. So Melanie has submitted the paperwork to rezone the site from R15 to B3. What rules control how the city processes Melanie's proposal to amend the Normalton zoning ordinance? What roles do Melanie, the neighbors, the city staff, the planning board, and the city council play? How is the council's action on a rezoning different from a decision on a special use permit? In addition to these general considerations, in this module, we'll address a couple of specific questions about zoning amendments. What steps in the process are mandatory under state law? What factors should the decision makers take into account? And what factors would be improper? What happens if a council member is biased or the decision would affect a member's personal finances? Give these questions some thought as we proceed, and we'll answer them before we finish.
All right, so keep a look at these three items, and as it says, things to consider when you have specific zoning amendments before you. Obviously, this is really geared to the council's decision, which they are the ones who are the decision makers. You guys are advisory, so you do make recommendations, but it's important to know exactly what factors should be considered, so you know exactly what your governing board is going to be looking at when such a proposal goes through the process. So look at what's prudent, what's improper, and what happens if there's a bias or there's personal financial interest involved.
An initial question is, who can initiate a proposal to amend a zoning ordinance or other local development regulation? The general answer is that anyone can petition the government to amend its laws, including the zoning map. As a practical matter, many amendments are initiated by the local government itself. The local government staff, the planning board, or even the governing board may start the process to consider an amendment. Most rezoning petitions are initiated by a landowner seeking to change the range of uses permitted on the property. Other interested parties, such as the real estate community or neighborhood groups, may also propose amendments. For the most part, state law only addresses the process that must be followed in considering a proposed amendment, rather than specifying how the process can be started.
My first opportunity to provide an update that will change with the new statutes that will come into effect the first of the year is that if there's a proposed amendment that would be a downzoning, that could not take place or be initiated by someone other than the property owner without the property owner's consent.
Once a complete application is in hand and any required processing fees have been paid, the local government starts the process to review the proposed amendment. The local government staff usually prepares a report analyzing the proposal and schedules moving the proposal through the review process. An initial step in the mandatory procedures that must be followed is a review by the Planning Board. State law requires that cities and counties submit all proposed zoning text and map amendments to the Planning Board for review. The Planning Board must be given up to 30 days for this review, but they can report on a recommendation earlier than this. If no recommendation is made within 30 days of referral to the Planning Board, the Governing Board is then free to proceed without a recommendation. Planning Board review of other development regulations may be required by local ordinance, but it is mandated by the state only for zoning amendments.
And of course, here, you guys are reviewing both text and map amendments.
There is no state requirement for a public hearing by the Planning Board. Some local ordinances require a formal hearing before the Planning Board or a joint public hearing before the Planning Board and Governing Board. But it is more common for the Planning Board to receive public comments informally during a regular meeting of the Planning Board rather than holding a formal hearing. The typical process at the Planning Board meeting starts with the staff briefly summarizing the proposal and the applicant explaining why they are seeking the amendment. The staff reports on their analysis and may offer a recommendation. Members of the public who wish to comment are generally allowed to do so. Then the Planning Board members discuss the matter and vote on a recommendation to the Governing Board. There are a couple of legal requirements about the Planning Board review that must be met. First, the Planning Board must make a written comment to the Governing Board. The written statement must be presented to the Governing Board prior to the Governing Board vote on the matter. So including the statement only in Planning Board minutes that are prepared and approved after the Governing Board meeting is insufficient. The written statement from the Planning Board must be before the Governing Board at the time that board acts on the matter. Second, the Planning Board statement must address plan consistency. The Planning Board must identify all adopted plans that are relevant and let the Governing Board know whether the proposal is consistent with those plans. Some states require that zoning amendments be consistent with the plan. That is not required in North Carolina. But the Planning Board and the Governing Board are both required to consider the plan and explain in writing whether the amendment is or is not consistent with the plans. The plan consistency statement does not have to be long and exhaustive, but it must be more than a simple checkoff. It must describe how the proposal is consistent or not. The statement may also address other matters deemed important by the Planning Board. For example, since the Governing Board has to address whether the amendment is reasonable and in the public interest, the Planning Board can identify and discuss factors that will help make those determinations. There is no requirement for a positive recommendation for the Planning Board in order for the potential amendment to move forward. The Planning Board recommendation is advisory only. The only legal requirements are that the statement be in writing, that it be presented to the Governing Board before they act, and that it address plan consistency.
And now I know you guys know that staff's been working pretty hard to try to get something more formal and written, and I'm not looking at anyone in particular, Cindy, but I know it does get hard to sometimes navigate that prepared statement and get through. So we're really trying to work for that. But now you see why it's so important that we do forward something in writing to the village council. One other change here with the 160D statutes that will take place is that now the governing board also will not only have to act on the proposed amendment and have their own statement of consistency like you guys, but a statement of reasonableness will also have to be included with that. So like typical statute, it's it's a little vague there. But we kind of have already been using those statements with ours because I stated is, in the best interest of the public. It's reasonable in the best interest of the public. And again, it doesn't have to be long and exhaustive, but state law is just going to require that you considered these plans. You can tell that someone looked at it and looked at a page and they considered it, and make that statement of consistency and reasonableness.
Let's take a look at how these requirements played out with Melanie's rezoning request. The planning board discussed the proposal at a regular scheduled meeting. Melanie, her planner and traffic consultant, the city staff, and 4 neighbors presented comments. The board concluded that some of the policies in the Normalton Comprehensive Plan supported the project. Policies encouraging more dense developments to be located along major roads, and those supporting increased commercial development within town. Other policies tended to point the other way. Policies on maintaining the residential character of established neighborhoods and limiting the traffic impacts of new development. The board decided to pass that analysis along to the city council without resolving whether the project would or would not be consistent with the plan. A majority of the planning board then voted to recommend denial of the rezoning, based primarily on neighborhood opposition. Since the planner was leaving town the next day for a much-needed vacation and would not be around to write up the planning board action prior to the council meeting, the planning board chair volunteered to go to the council meeting and present the board's recommendation. Which of the following statements about the planning board review of Melanie's rezoning request is true? 1, the analysis of plan consistency is inadequate because a description of how plan policies are implicated is insufficient. The board must come to a yes or no conclusion on plan consistency. 2, the city council must deny the rezoning based on the planning board's recommendation for denial. 3, an oral report on planning board review is inadequate. The board's analysis and recommendation must be in writing when presented to the city council. On the next slide, you'll be asked a question regarding this rezoning request, and when you submit your answer by clicking the Submit button, you will receive feedback. When you are ready to move to start the quiz, select the Continue button on the slide.
Okay, I'm going to try not to put no one really on the spot here. Dave did a pretty good job of kind of outlining that, but here's your 1, 2, 3, or ABC that he says. So it sounds like there was no real conclusion by the board. They could not come to a agreed consistency statement, but as planning board chairs are so involved in their duty, has offered to be there at the village council meeting the next day their next meeting to state why. So, any takers here?
C.
Correct.
Please excuse my back. In the meantime, I can see it better up there, and these things are going that way.
All right, so general consensus is C? Good job.
You may continue with the module by selecting Continue on.
A vital part of the development regulation amendment process is the public hearing. Other means of securing public comment are certainly allowed, but a formal hearing is mandated by the statutes. State law also mandates specific notice of the public hearing that must be held for legislative decisions to adopt, amend, or repeal a local development regulation. A local ordinance can add additional notice requirements, but it must at a minimum meet these state requirements. State law mandates that an advertisement for the hearing must be published twice in separate weeks with the first notice at least 10 but not more than 25 days prior to the hearing. This published notice must appear in a newspaper of general circulation. Putting the notice in an advertising circular or a homeowner's newsletter is not sufficient. The published hearing notice is required for all proposed amendments to any local development regulation, rezonings, and amendments to the text of any development regulation. A couple of additional hearing notice requirements are necessary for proposed zoning map amendments. For zoning map amendments, a notice of the hearing must be mailed to the owners of the affected and the abutting properties. The notice must be mailed to whoever is identified by the county tax records as owners of the property being rezoned and all property that abuts or touches the property. An updated title search to determine whether the property has changed hands since the tax listing is not required. This mailed notice must be sent first class. It does not have to be sent by return receipt mail, though local governments may do so in order to get an official record of delivery. A city or county may require someone proposing a rezoning to compile the list of owners who get this mailed notice, although the staff usually does the actual mailing. Some local ordinances require the mailed notice to be sent to all properties within a set distance of the property proposed to be rezoned, typically properties within 100 or 500 feet. An ordinance can require mailing the notice to more property owners than is required by the state statutes, but not to fewer owners. If an expanded mailing requirement is placed in an ordinance, it is binding and must be followed.
And our ordinance just mirrors the statute. So we do mail the notices to the affected and abutting property owners. Obviously, within some of Pinehurst, the way the built-upon area is designed, sometimes it's a little difficult to really define if someone's abutting or not. So we always go above and beyond just in case. And we do the mailings in-house, and we do certify that those adjacent owners, that we certify a notice that we mailed these certain folks, and we include a map and then a copy of all the folks who were mailed that notice.
The public notice that appears in the paper has to be done within so many days. How many days in advance of the hearing does the mailed notice have to go out?
It has the same 10 to 25 day time period, and I appreciate the opportunity now to state, because of what newspaper of local circulation we have, in order to get those 2 consecutive weeks and notice between 10 and 25 days, our newspaper only has circulation days on Wednesday and Sunday. So we have a very strict time frame, and we have to have something sent to the pilot by noon on Thursdays now, I think, for the Sunday paper, and Monday by noon for the Wednesday paper. So we got that 10 to 25 day window, so we have to stay on it.
The city or county staff should maintain a copy of the notice that is mailed, a list of the recipients, and a certification by the person making the mailing as to when it was done. The mailing is conclusively presumed to be valid if that certification is made, unless there's a showing of fraud.
One thing staff is starting to do now, too, you guys may have noticed it with last month's Board of Adjustment meeting, we are actually going to, within your agenda packet, starting to include the notice that was mailed to the property owner. So you'll see that language. You'll see the list of folks who were mailed that notice, and then you'll also see a map.
And certified mail is not required.
Not required, just first class. At some jurisdictions make that their policy, but ours is, we stick with the statute.
If a proposed rezoning or a zoning text amendment changes permitted land use on property within 5 miles of a military base, the hearing notice must be sent by certified mail to the base commander. Other means of delivery that will provide actual notice to the base commander may be used, but documentation of receipt of the notice is important. This notice to the base commander must also be made when reviewing text amendments relative to telecommunication towers or windmills, or a provision for a new major subdivision or substantial enlargement of existing subdivision within 5 miles of the base. Local governments have an alternative to mailed notice for larger rezonings. If a rezoning covers more than 50 properties with 50 different owners, local governments have the option of substituting 2 half-page newspaper ads for the mailed notice. If this alternative is used, a mailing must still be made to property owners who live outside the newspaper's area of circulation. On-site posting of a hearing notice is also required for all zoning map amendments. Each local government has discretion as to the number and size of the signs that are used and on the timing of the mandatory posting, so long as the posting provides reasonable notice to interested persons. The statutes do not mandate the content of the sign. Wording such as zoning hearing notice or public hearing is sufficient. Most signs include contact information, such as a phone number for the city or county planning office to obtain details about the hearing or the proposed action. If multiple parcels are proposed for rezoning, it is not necessary to post each parcel, but sufficient notices must be posted to give reasonable notice of the proposed action. If a rezoning is initiated by someone other than the owner of the property affected or the local government, the landowner must be provided actual notice of the hearing. This notice can be accomplished by personal delivery or by a mailing that verifies receipt. The content of the published and mailed notice should include a brief description of the subject of the hearing, the date, time, and location of the hearing, and a contact source for more detailed information. Many notices also advise that changes to the proposed amendment may be made in response to comments received. The full text of an amendment does not need to be included, but the explanation should have enough detail to allow an interested person to understand the nature of the proposal. The general rule of thumb is to put sufficient detail in the notice to let an average citizen know enough about what is being proposed to decide whether or not to attend the hearing, submit comments, or to seek more information. For example, it would be sufficient in our case if the notice said the purpose of the hearing is to receive comments about a proposal to rezone the property at 1521 Main Street from single-family residential zoning to commercial zoning. Okay, consider this situation as it applies to Melanie's rezoning request. A notice of the City Council hearing was published in the Normalton Gazette 2 weeks before the hearing and again the week before the hearing. A sign about the hearing was put on the site 2 weeks before the hearing. However, due to a clerical mix-up in the planning office, notices of the hearing were not mailed to the neighboring property owners until 4 days prior to the hearing. On the next slide, you'll see 3 statements and select the one that is true. Once you have selected the correct answer, click the Submit button to receive feedback. When you're ready to move to start the quiz, select the Continue button on the slide.
So again, which one of these following statements is true? Since a sign was posted, is the mailed notice redundant? So C again. 100%
The
so
correct
far.
answer is C. All of the various notice requirements must be strictly met. The statutes require that the mailed notice be deposited at the post office at least 10, but not more than 25 days prior to the hearing. The fact that some or even all of the neighbors may have actually gotten notice does not excuse a failure to meet the statutory notice requirements.
You may continue with the module by
The night of the hearing on Melanie's application to rezone the Main Street parcel has arrived. Melanie is ready to tell the council why they should approve her request. A room full of neighbors are present and ready to tell the council why Melanie's proposal would have a terrible impact on them. While some rezonings are routine and non-controversial, rezonings are often one of the most visible and hotly debated issues that come before city councils and county boards of commissioners. The decisions have a significant impact on the landowner, the neighbors, and the future of the community. There are often large financial stakes involved, and emotions can run high. What rules apply to how the governing board conducts these hearings? The key factor here is that public hearings on a rezoning and for all text amendments is legislative. The purpose of the hearing is to let members of the public tell the governing board why this would be good or bad. Getting citizen advice and opinions about the matter is the whole reason for the hearing. There may be numerous technical issues to consider, but ultimately rezoning is a policy choice to be made by elected officials who have to decide what is best for the landowner, the neighbors, the public, and the future of the city or county. These legislative hearings are very different from an evidentiary hearing and a quasi-judicial case. In those cases, special use permits, variances, appeals, the purpose of the hearing is to gather competent material evidence as to whether standards in the ordinance have been met. The rules for evidentiary hearing, such as witnesses under oath, limits on opinion testimony, and gathering evidence outside of the hearing, are discussed in detail in the module on evidentiary hearings. On the other hand, with legislative hearings, speakers need not be under oath, and they are free to express opinions about the wisdom of the proposed action.
And this is where you guys get to walk that fine line, because you guys are pretty much the sole board and group of volunteers, not elected officials, that act both in a legislative capacity as well as a quasi-judicial capacity when you guys are sitting as a board of adjustment. So it's very important that you know the key difference. And again, with amending the map or the text of the ordinance, it is all legislative.
That is not to say that no rules can be applied to public comments at legislative hearings. Unduly repetitious or irrelevant comments can be barred. Reasonable time limits can be imposed. For example, each speaker can be limited to a set time, such as 5 or 10 minutes each. Each side could be given a set time to present their case, or a total length could be set for the hearing. It is acceptable to allow only a single person to speak to represent a group with similar concerns, with perhaps a showing of hands by all of those who agree. It is appropriate to have sign-up sheets to manage participation. While public hearing rules of this type are common and legally acceptable, care should be taken to conduct an essentially fair hearing. For example, the local government should not allow the rules to be manipulated to permit one side in a contested rezoning to monopolize the entire hearing without giving the other side a reasonable opportunity to comment. Once the City Council has considered Melanie's application, the staff analysis, the Planning Board recommendations, and public comments, they deliberate and make a decision. What factors can the council consider in reaching a decision? For the most part, the decision on how particular properties should be zoned and the substance of development regulations is left to the good judgment and discretion of elected officials. There are statutory and constitutional protections for a few particular land uses. These will be discussed in future modules. But for the most part, the decision is within the discretion of the governing board. If local residents conclude the elected officials are making bad zoning ordinance decisions, the remedy is usually at the ballot box rather than at the courthouse. There are nonetheless some general guidelines on legitimate and illegitimate factors when considering any development regulation amendment. The primary consideration when reviewing a potential amendment to a development regulation is the potential future land use impact on the landowner, the neighbors, and the public. Factors such as the suitability of the site for the proposed uses, impacts on traffic, utility availability, impacts on the environment or neighborhood character, and on school capacity are all legitimate considerations. Will there be adequate public infrastructure to support the development that would be allowed? Would the development unduly harm neighboring property values or otherwise adversely affect the surrounding neighborhood? What sort of fiscal impact would this have for the local government? What sort of precedent or pattern would this set? Would this advance the goals and policies set in the comprehensive plan? All of these are fair questions and legitimate questions to ask when considering a rezoning.
So a very wide net of things to consider.
Can we give
There are several factors that may not be applied.
I wanted to address the thing that was talked about, the time limits and having like many. I know in my previous planning board, which was much larger as far as area and stuff, we had time limits for each side. If there were like 10 people on one side, then they could have the 3 minutes per person, or they could have, 10 minutes for one person. And I think that Darren and I have talked about this quite a bit, that we do need to address that as a board, because David, I think you'll probably remember when we had somebody come up and kind of took over, and I don't think it's fair to the public who comes to the meetings to not see us do something like that. I think it's much more professional. It's fair. If everybody gets the same amount of time, if one side doesn't want to use it or there isn't anybody, that's fine too. But I do think that that definitely needs to be addressed.
And that's a fine point. And that is mirrored in the board's rules of procedure that were adopted. We do have that option. It's a fine line to walk. You don't want to seem, as they stated, like you're giving one side or the other more time, even though there's more representation at the meeting. Of course, as they also mentioned, sometimes we have 3 or 4 folks in the audience whenever we have a public hearing. Sometimes it's standing room only. So when you have that many people there and you want to give everyone that opportunity to speak, then that's when you may want to look at imposing some time limits. Or I know Leo has done this too. If you know there's going to be redundant comments made, you can see if the group would by a show of hands, elect a spokesperson. So, we don't want to draw it out to a midnight, a 2 a.m. hearing, but we do want to be able to have everyone and allow everyone a fair chance. But there's not a one-size-fits-all for that. It varies. But I do think Sonia brings up a good point that some of these cases and some of the ones that you guys have been involved with, you could see that, okay, if everyone had 2 minutes or 3 minutes, that's enough to get what points you need to get out there and get across.
Well, I think that's what he's basically saying. I mean, if you have that policy, then when you send out your notice, you also put that in your notice. I mean, it's not like punishing someone. It's an order of policy that you need to do. Because I don't think it's appropriate to do it when you have a house full of people and then make that decision. It's just not appropriate. I think it needs to be done ahead of time, and that is the policy for each and every single time. I mean, it's really pretty simple to do that. Do you not agree, Deborah?
I think the times that we've had a situation here where we've had to think about that have been few in the last 6 years that I've been serving. But I could see, like the one evening when we had 76 people that wanted to speak, and I kind of let everybody say their piece and went through it, and it was a good 2.5 hours worth. But having some sort of limit of X number of people per side and then X number of minutes is not a bad. We could say something like, in general, in our rules of procedure, in general, not more than 10 speakers representing each side, and each speaker not be allowed more than, in general, not more than 5 minutes, or something like that, I think could be a good limit.
I think that's going to have to be on a case-by-case basis also, depending on how many people are going to be showing up for a public hearing. I don't have any problem in saying on our public notice that the public may be limited to 5 minutes for their objection or whatever they want to say. But if there are multiple people from the same group, I would like to have them nominate a spokesperson to make their case. And I think that has to be adjusted on a case-by-case basis at every meeting that we might have, a public hearing.
The challenge to that becomes the group's organization, because when 76 people show up here, they don't know, elect a group representative. I don't even know who's in my group here. But if we put out something like that beforehand, in generally this will be followed. Then, like the point I can remember in the meeting where you said, okay, well, we've heard that 5 times now. Does anybody have something different to present? And you kind of can get into that with the limit, a general limit. You can always waive the general limit and you say, hey, this is a particularly contentious issue, so we're going to hear from 20 from each side tonight or something like that.
That's exactly what I was talking about, because I think in this one particular meeting, it was almost biased that we give that person a read thing, so forth and so on. So I think if we send this out in the notice, and like I said, Darren and I've talked where he came from, that was definitely in their notices, and that's how it was done. But again, if there is something special, we can always decide that night if we want to give them a little bit more time. But I think we do need to send a precedence with, this is how it's done, this is how many minutes. If you're a big group, please try to have 1 speaker, have 3 speakers, or whatever. I mean, that just makes common sense to me. I mean, just order.
I like the idea of having something general because it's Pinehurst and we don't have a lot of big issues every month. So, having something general would be fine, but I think each one has to be considered on its own, just to support Pinehurst.
I think the comments, Leo, that you've made a few times, that redundancy is not necessary, are the most important policies. I don't know whether people adhere to that, or they understand, or that what they're saying is repeating what somebody said 10 minutes before them. But I think once a point's been made, beating it into the ground by 10 people is just not purposeful to the case. I don't know how you stop that, except to just make that statement in the beginning, that if what you've said, what you plan to say has already been said, please consider or reconsider whether you want to come up here and just repeat that. That's about all I think you can do.
Again, that's going to have to be determined at the meeting on a case-by-case basis. And I don't object to having some kind of general statement in the notice that says, depending on the amount of people present, presentations may be limited or something like that.
And one thing that staff can look at is we can look at lifting the language as in the current rules of procedure and placing that right in there, which it is a general statement that speakers may be asked or time limits may be placed on those who wish to attend and speak. So it sounds like we've maybe uncovered something that maybe in the future maybe the board wants to discuss. Maybe when we've got a pretty good representation here tonight. We've got 8 out of 9 members, but this maybe it's worthwhile having some further discussion on. Thanks for that.
There are several factors that may not be a part of these decisions. These include the race, ethnicity, religion, income, or character of residents of the proposed project. Factors unrelated to land use impacts are also off limits. For example, our courts have held that whether a residence would be owner-occupied or occupied by renters is not a legitimate zoning consideration. The land use impacts of permitting multifamily development can certainly be considered, but whether the building is an owner-occupied condominium or a renter-occupied apartment building is irrelevant for zoning purposes. Unlike quasi-judicial decisions, no written findings of fact are required for ordinance adoption, repeal, or amendments. There is no requirement for substantial evidence to support the decision because these are policy choices for elected officials. However, the governing board must approve a written statement on each zoning amendment decision that addresses plan consistency and how the decision is reasonable and in the public interest. The substance of the governing board statement is not subject to judicial review, but its existence and whether it includes a description and explanation is subject to judicial review. Having a written statement from the staff or planning board in the record before the governing board is not sufficient unless the governing board affirmatively approves the statement. A checklist or conclusory statement that the amendment is consistent with the plan and is reasonable is also insufficient. If the rezoning involved is a spot zoning or conditional zoning, the documentation that there is a reasonable basis for the decision is all the more important. Additional information about spot zoning and conditional zoning is included in the modules on these topics. Consider this. Melanie has submitted detailed traffic engineering reports that show how the traffic expected to be generated by her project will be handled. These reports show that if left turn lanes are added at entrances to the site, the existing city streets can handle the additional traffic. The city traffic staff has submitted a report concurring with this analysis. However, a large number of neighbors spoke at the hearing about their belief that the project would lead to adverse traffic impacts on their neighborhood. While offering their concerns, the neighbors had no expert analysis to offer. If the city council agrees with the neighbors, can it deny Melanie's rezoning request because of adverse traffic impacts? On the next slide, you'll be able to select the correct answer, then click the Submit button to receive feedback. When you're ready to move to start the quiz, select the Continue button on the slide.
Sorry.
So the answer is yes.
The correct answer is yes. If this were a quasi-judicial special use permit, reliable evidence would be necessary in the hearing record to support the finding that the project is unsafe due to traffic problems. However, with a legislative decision, the council may consider citizens' opinions about the desirability and wisdom of the proposed amendment. Expert testimony is not required to support the council's discretionary decision on a rezoning.
You may continue.
There are two additional factors that need to be addressed before the governing board votes on Melanie's rezoning request. The first is determining how many votes are required to adopt the amendment, and the second is determining which members are eligible to vote. The voting statutes generally require that amendments to ordinances be adopted by a simple majority of all members of the governing board, not just those present and voting. In addition, For cities, a two-thirds vote is required to adopt the amendment on the date of introduction. And for counties, a unanimous vote is required to adopt the amendment on the date of introduction unless a public hearing is required. Since all zoning amendments require a public hearing, that unanimous vote requirement does not apply to county rezonings and zoning text amendments. Unlike other city ordinances, with zoning amendments, a council member who is present but does not vote is not automatically counted as an affirmative vote. A city council member can abstain from voting on a rezoning or text amendment. However, the seat of a council member who abstains is considered in computing the required majority. A second important factor about voting on an amendment to a development regulation is avoiding improper conflicts of interest. It is important to remember that these are legislative decisions, and elected officials generally have an obligation to vote on every case. Unlike a quasi-judicial decision, governing board members do not need to be impartial. They may discuss pending cases outside the hearing, and they may hold firm personal opinions about the desired outcome. But if a decision would have a direct, substantial, readily identifiable financial impact on a member, that member must not vote on a legislative zoning decision. This rule applies both to the city council and the planning board. The member may participate in the discussion, but may not vote. The seat of a member who does not vote due to a financial conflict of interest is not considered in computing the required majority. Some local ordinances prohibit members with a financial interest in the outcome from participating even in the discussion of the case, which may well be a good practice, but it is not mandated by state law.
Right. So our local ordinance does not prohibit any of discussion while you sit on and hear a matter. And you guys do know, as has happened before, it is certainly allowed if there's a proposal for a map or a text amendment before you guys to be contacted by folks who are interested in that, have discussions about it, have discussions with yourselves about it. This, again, is strictly legislative, so let's let you know that is okay, that is fair game. It's somewhat part of your duty, if you want to put it that way. But just keep in mind, anytime there is if you're sitting with the Board of Adjustment, that is a great big fat no-no. Joel's got a question.
I'm assuming these are linked together, direct, substantial, and readily identifiable?
Correct.
Thank you.
That is directly lifted from the statute, that language right there.
So those are not three separate items?
Correct. It is all one, but they are meant to guide you to that.
Can we go back to the traffic question?
Not you, Leo.
Melanie can appeal that decision.
Certainly.
To what board or body? Does that go to Superior Court?
First review would be by the local Board of Adjustment, and then it would then go to Superior Court.
And that's where the local Board of Adjustment has the quasi-judicial
And obviously put in a
content.
It kind of puts you in a could put you in a pickle.
What's the standard of review?
The appeal is just there's a record that is made. You have the decision, you have what the outcome was, then you have what was presented at that hearing, and anything that the board or the board chair seems is prudent to determining that effect. I mean, they couldn't just, there would have to be some merit to the appeal and just say, I don't like that they said no.
No, it can't be a de novo review.
Correct. And if you recall by some of the language in some of the slides we saw earlier, someone has to, in order for the Board of Adjustment just to even really consider it or take it up, they would have to have some sort of basis or ground, like,
It would have to be abuse of
What-
discretion,
w-
isn't
w-
it?
was there a consistency statement? Did someone, I mean, again, if they would have to, they would have to appeal on a basis that they didn't meet one of their requirements, because again, it is solely discretionary in what the decision is.
Consider this. Matt Jones is a member of the Normalton City Council. He lives in the neighborhood adjacent to Melanie's proposed development, but on the opposite end of the neighborhood. His house is about 10 blocks from Melanie's property. He is a former president of the neighborhood association and ran for city council as a vigorous neighborhood advocate. Matt attended a neighborhood meeting the week before the rezoning hearing where there was extensive discussion of the proposed rezoning. Matt's wife signed a petition opposing the rezoning. The day before the hearing, Matt told a reporter for the Normalton Gazette that he had been elected to the city council precisely to stop the sort of travesty being proposed by Melanie. Is Matt allowed to vote on this matter? On the next slide, you'll be able to select the correct answer, then click the Submit button to receive feedback. When you're ready to start the quiz, select the Continue button on the slide.
So Councilmember Jones is quite active, and I'm sure his constituents are happy for that. He's holding out his public duty here. One thing I did want to mention is that very first paragraph there. As you know, within our ordinance, we do require, if there is what we term an upzoning, a proposed rezoning for anything that's more intense than the initial zoning, we require that the applicant hold a neighborhood meeting themselves and prepare us a list of those who were mailed, a list of those who attended, and a brief summary of what happened. Our ordinance does state, however, that a council member, and so this, just council member, but it's probably a good practice for you guys, that you shall not participate in one of these neighborhood meetings in your official capacity. If you're a neighbor, if you were invited because you were one of those neighborings, then you're a citizen first too. Don't forget that. So you can sit in that. So we'll move on and see what we think Matt can do. He's not allowed to vote based on basically his points that are kind of made outside of the hearing. He's not allowed to vote due to his close association with the group and his spouse. He's not allowed to vote because he has expressed a conclusion about the outcome prior to the hearing. Or D, he must vote unless the rezoning would have a substantial impact on his property value, which is unlikely given the distance from his home to the site. We can't hear you, Joel.
My question is, in D, it says he must vote. Do they mean must or may?
Could abstain. He wouldn't want to, but he could. I agree with you, Joel. That word is strange.
You don't have to vote.
It's a little conflicting from the previous slides that we just saw, where you could abstain, and it's not necessarily counted as an affirmative vote, but his vote would be, or his seat would be calculated in the required majority.
So this should read, he may vote.
So Joel has proposed a change to how letter D is wording.
I'll second Joel's proposal.
All right, so vote on the matter.
Modified D.
Modified D.
That's another nail in the coffin at Board of Adjustment.
That's right.
Yeah, now the guy can appeal.
The correct answer is D. If this were a quasi-judicial matter, the discussion outside of the hearing, ties to those opposing the project, and having a bias could disqualify her from participation. However, with a legislative decision such as a rezoning, impartiality is not required. Thus, she is required to vote unless there is a financial conflict of interest.
All right, so you guys are making me proud here. So not only did you get the answer correct again, but you modified it, so you're paying attention. So it tells me that something's happening here. And then you guys also alluded to the Board of Adjustment, the quasi-judicial, which is covered in the answer, so good job.
You may continue with the module by selecting
Another key difference between legislative and quasi-judicial decisions is whether they may be reconsidered. When a final quasi-judicial decision is made, it is binding and the board has no jurisdiction to rehear the same case. There must be some material change in the application, the ordinance, or conditions on the site in order to bring it up again. By contrast, there is no statutory or constitutional limit on reconsideration of a legislative zoning decision. This raises the prospect of a disappointed applicant for a rezoning bringing the same case back to the city or county time after time. This could place a real burden on the neighbors, the staff, and local boards having to review the same project multiple times. To prevent that inefficiency, many local ordinances provide that once a decision is made on a rezoning proposal, no other zoning petitions affecting that property can be considered for a specified time. The time limit varies, but is often 6 months or a year. Each ordinance specifies what triggers a waiting period. It may be a hearing on a rezoning for that parcel, defeat of a rezoning, or some other defined point in the zoning amendment process. While a waiting period is not mandated by state law, if a waiting period is placed in a zoning ordinance, it is binding and it must be observed.
All right, so anyone have a clue about what our ordinance states? Do we speak to this? And if we do, you guys know what the limit is? Or what the point of no return sort of is?
Is it 1 year?
Leo says, yes, we do, and it's 1 year. I agree with Leo. Also, we state that basically once a proposed amendment has been noticed for the council hearing, so they don't even have to go all the way and hold the hearing, but once it's been noticed and placed on the agenda for village council, and the application were either A, withdrawn, or were denied, then there's a waiting period for a year. The only option out of that is a majority affirm vote by village council can waive that waiting period. So you're going to have to go before, you're going to have to get some sort of okay from them before you can try again within a year. And this has come up before, most recently.
Legislative regulatory decisions have a significant impact on property owners, neighbors, the community, and local governments. State statutes give great discretion to each city and county to determine what regulations are best for their own situation. But state law sets detailed, mandatory procedures that must be followed to assure that all of those affected by these decisions are aware of proposed amendments and have the opportunity to make their views known prior to the decision. A review by the planning board is mandated to help produce decisions that are carefully and thoughtfully considered. Public hearings on a proposed amendment are required and they must be fair. But the hearing is an opportunity to offer comments and suggestions, not the presentation of testimony like a court proceeding. Amendments are adopted or rejected by simple majority vote of the governing board. The exception is where there is a valid protest petition for a city rezoning, which triggers a 3/4 majority vote requirement. Planning board and governing board members are not allowed to vote on matters that are likely to have substantial financial impact on the member. These requirements are intended to establish a consistent, open, and fair process. Carefully following them is not only a legal requirement, but helps ensure public confidence in the integrity of the process.
All right, so that covered amending and adopting the ordinance and the maps. I hope it's been beneficial for you guys and for those in attendance. We did have one more scheduled on the agenda to talk about conflicts of interest. I didn't intend for that one to go so long, but if you guys want to proceed with the conflicts of interest module, it's a little bit shorter, and hopefully I won't have to talk as much.
Next time? Next time. Oh, you want to go ahead? Oh, next time. Okay. Well, I guess we'll suspend activities then for the evening.
One other thing staff can do, and we also have, other advisory boards who we can work on doing these outside of the main meeting, but I do like having this opportunity so you guys can have a little healthier discussion. I know maybe it was a little over a year ago, I did more of the evidentiary hearing and more of the quasi-judicial things, and I know Leo, Cindy, Julia, I know you all attended. I think Joel came for that as well. So we've had some new faces. So, Jeremy, Sonia, and Philip, I'd love to be able to give you guys as much info as I can too, as time permitting. So we can certainly look and see what's coming up next month, and maybe look at hitting another one or two. We could start dabbling a little bit into like variant standards. I have that tab open too. These can be beneficial, and if you guys want to provide any feedback to me, send me an email. Let me know any topics you're interested in. I can do these things one-on-one. We don't even have to watch these unless you just really want to listen to Mr. Owen some more.
Alex, I know it takes up a lot of your time, but I do appreciate the opportunity that we had last year to come in and maybe look at these and have that type of discussion. So whatever, I'm willing.
And I apologize, I forgot that you came and attended those away. You were brand new at the time, I believe.
I'll do some more.
Appreciate that. All right, Leo, I'm turning it back over to
All
you.
right, thank you. And I hope the folks in the audience learned something also. Next meeting, April 2nd, 2020. Is there anything that anyone has to bring before the board at this time? If not, I'll ask for a motion to adjourn.
I'll move that we adjourn.
Second.
Motion by Cindy, seconded by Sonia. All in favor? Aye. Good evening, and see you next month.